Welcome, everyone. We're ready to get our webinar going. I've been looking forward to this discussion, and now we're live. I'm kicking us off from here in Boston, and I'm going to be joined by presenters from across the US. We will be discussing a topic that's hot for many of us. It's hot for the industry: data privacy and security. So these important topics, they are moving fast, and we're going to move fast and have some fun today. But since we are covering legal topics, we got to get started on the right foot. So a little moment here of a cautionary statement. We are going to be talking about legal topics, but they are for informational purposes only. All information here is general and high level. Do not take it as legal advice. And also, nothing that we'll be presenting or discussing should be considered without reviewing it with your own lawyer and considering your own laws, rules, and regulations for where you are based. And also, we have an attorney on the call, so do not take this as establishing an attorney-client relationship. All right, compliance is out of the way. We can dig in. It is an amazing time to work in events. We all know this. It's small moments like being surprised when something comes to life, or bigger moments like when you can connect with somebody with technology in an interesting and meaningful way. Or on the back end as event professionals, getting all the data from that technology to change in near real time or live the experience our attendees are having. But that's just pieces of today's reality. We want all of that, and we want more. If we're a marketer, we want more tools, data, analysis. If you're an executive, especially off of yesterday's news of the Capital One data breach, it's on top of mind for all executives around security and compliance. There's more attention than ever to this. But as attendees, we as individuals, those 100 million people maybe on the Capital One side, we as attendees, we want more transparency, we want more value, and we are hyper aware of these realities. So what's coming together in the world of events is this convergence. These three areas, one area of focus in the middle, and that's where we're going to be focusing today. We have a three-part show with a discussion at the end. We're going to start by talking about the current state of data privacy. We're going to dig into the changing landscape of that compliance world we live in. And then we're going to talk about what's coming next, the emerging technologies that will bring more data and more privacy into our lives. There is a discussion that we're going to be having at the end. Here in Zoom, down on the bottom, you'll see a Q&A button. Throughout the program, please add your questions. We'll leave plenty of time at the end to dig in. So any questions, as wonky or as fun as you can throw at us, we're going to be ready for them. So who is the we? That's me on the left. My name's Brent. I work here in Boston for Opus, and we are joined by Chris. He is the Chief Privacy Officer of Trendline Interactive, based down in Atlanta. Good morning, or good afternoon, Chris.
Hey, good afternoon. Thank you for having me.
Thanks for joining us. And then Howie, working with me here out of our Portland office, our Senior Corporate Counsel for Opus. Good morning, Howie.
Good morning, Brent.
All right, so first up is Chris. He's going to be digging into, as you can see here, the state of data privacy protection. Take it away, Chris.
Hey, thank you so much. And, just like you were mentioning, the, Capital One data breach has definitely taken a lot of people by surprise. And, it's sort of a bit of an expectation that we get on a Monday morning news, Tuesday morning news, whatever the case may be, right? We're in the midst of essentially, I think, a crisis around the world. Data breaches are happening far too often, and we need to start to recognize the costs, right? Data breaches, of course, not only cost companies, but they cost consumers, they cost taxpayers. It's a travesty around the world, and clearly you can see that Capital One is just one of many. Uber, Equifax recently approved a $700 million retribution due to their data breach, which in many estimates are not enough. And you can see clearly the cost of data breaches around the world. The United States, Canada, Germany, France. It's not just the U.S., but in the United States, it's really become an area where we play fast and loose with consumers' data. And that's where CCPA really starts. And we'll talk about CCPA and the emergence of that. But again, for the most part, what I want to focus on is really what rights the consumer has, as well as what are some of the things that are happening around the world. Some of the drivers that are fueling these concerns, right? We just talked about data breaches, but also, again, tech innovation. We're at a place now in 2019 to where, you know, a lot of companies like Facebook, LinkedIn, Google, Microsoft, they have a lot of data on consumers. And they use it in ways that make our lives easier, maybe faster, more efficient, but at the same time, at what cost? And that's a concern, again, not just in the US, but around the world. Media attention, again, turn on the news, read any news article, source, and you'll clearly see that data breaches are happening. Too much information is being accessed. Individuals' rights are being taken away as it relates to not being able to edit their data, have access to their data. Data misuse. I don't know how many times I've read about third-party vendors doing things with consumers' data that they shouldn't have been doing. Third-party contracts that Howie will talk about as it relates to a controller and a processor, and the processor doing things that the controller said don't do. Political attention. The debates that have happened over the past few months have brought this up, as well as ongoing concerns with, hey, is my information being shared with Russia, with China, with Mexico? Where's my data being held, and who has access? As well as advocacy groups, right? There was a shirt that I saw not too long ago that said, you know, in 1997, your parents said, don't talk to strangers and don't sleep at strangers' houses. And now in 2019, we have Uber, we have Airbnb, we have Lyft, and we're giving that information to these companies. But how much is that really worth? And we'll talk about that too as well. A little bit of an overview. There's a few different anti-spam data protection laws that are out there. Many of you are familiar with CAN-SPAM, of course. That's the version of the United States as it relates to anti-spam regulating commercial electronic messaging. It's been around for a long period of time. Many of you that follow any sort of policy or privacy legislation have seen that there are concerns about CAN-SPAM as it relates not just to opt-in, but to also things like where the data is held and controlled, but also things like, when I'm unsubscribing, am I really unsubscribing? Is it my information really being removed, and so forth? CAN-SPAM, of course, as I mentioned, been around for a long period of time. Really, the crux of CAN-SPAM is that it's not an opt-in law, it's more of an opt-out law, and of course you have to honor those unsubscribe requests. Some of the other nuances, the subject line has to match the body of the message. So you can't say free iPad in the subject line, but then require people to fill out 100,000 surveys for sweepstakes to maybe win a free iPad. Counsel is the Canadian anti-spam legislation that was came into effect July of 2014. That also regulates commercial electronic messages for Canadian residences. It affects email, SMS, audio, video, a lot of things, not just email related. Fines are pretty hefty. And of course, it is a opt-in rule. So it means that you need to have an explicit opt-in for the individual in Canada to be able to send those emails to the individual. You had a period of time to get that explicit opt-in. If you had an implicit opt-in, and an explicit opt-in is essentially that you're physically checking a box or doing something to explicitly state that you do want to receive email from the company. Counsel kind of came in as a whirlwind, and then quickly after that, GDPR, the General Data Protection Regulation, came into effect May 25th of 2018 from an enforcement perspective. I call it Counsel on steroids. GDPR really doesn't necessarily focus on that explicit opt-in as much, but it is a requirement of GDPR. Again, that opt-in rule of having somebody physically check that they do want to opt in to receive messages or information about from your company. GDPR takes it to the next level and focuses on rights of the consumer, of the individual, the right to be forgotten, the right to be edited, the right to data portability, receiving the data about them in a free format so that way they can access it and see what information you have about them. GDPR goes into a lot of other nuances, things like assigning a data protection officer, breach notifications, some of the other things we'll be talking about here in just a second. So again, for GDPR, really the aim was to again secure and make sure that the consumers' rights and the data privacy and protection is in, I'd say, full enforcement and 100% magnified. Really, again, for GDPR, it's about that explicit opt-in, but it's also about the consent of the consumer and what information is being collected, stored, accessed, retrieved, edited, and where the data is flowing, right? So again, for instance, if you are a controller of the data and you have a third party that's going to process the data, what sort of protections have been put into place to transfer the data, who has access to it, and then what is that third party going to do with it, right? So oftentimes, if you think about it, when you sign up for a credit card, not calling Capital One out in this case, but you sign up for a credit card, and then you're opting into having that information being sent to other third parties that may use that data in a survey, a trend analysis, a chart, a graph, or selling it again to somebody else. And so that's really the crux of what's happening in today's landscape, is not just, okay, am I opting in to receive email? Am I opting out? What's happening with my data? But it's about who has access, rights, and who can get that data. Mentioned some of the rights now of the individuals. Again, right to be informed, how the information is being collected and processed, right to access, so you can, again, access that data either through, again, a business process or technical means. Right to rectification, right? So if your information is inaccurate, this is a big thing, especially as it relates to data appends. We hear this all the time, is that, hey, I received a piece in the mail and it said it had my wrong title, had the wrong company name, but it had the right address and the right first name, right? So it could have been the victim of an append gone wrong, and being able to rectify that. The right to erasure, right to be forgotten, right? So this is a big thing that a lot of companies are staying up late at night about and wondering, okay, well, if somebody writes in or calls in and says, I want the right to be forgotten, how does that information trickle down to other processes and other systems, so that way I can make sure that this individual is essentially, quote unquote, forgotten. Restricting of processing. So essentially, if somebody has the right to, again, write in, contact you and say, stop processing my data. Portability, as we talked about, free human readable export of your information, so that way you can take that data, know exactly what the company had on you, and keep it for yourself. Right to object using the data, and of course regarding automated decision making, right? So any sort of automated decision making, you have the right now to not to be subject to that. And again, these are huge sort of rights that essentially took GDPR to the next level of concern, not just for event marketers and email marketers, but lots of companies and corporations around the world. How am I going to adhere to all of these from a consumer's rights perspective and be able to still do my job, sell my lists, sell my product, and whatever the case may be? So again, GDPR really took it to the next level. But here in the United States, California has really stepped up from a protection and the rights of the consumer, and came into created CCPA, the California Consumer Protection Act. CCPA was signed into law in 2018, went into effect January 1st of this year, goes into enforcement January 1st of 2020. CCPA is really for the for-profit companies that are doing business in California that meet one of these criteria. It's businesses that have over 25 million in gross revenue per year, and or businesses that buy, receive, sell, or share personal information of over 50,000 consumers per year, and or businesses that derive 50% or more of the revenue from the sale of consumers' personal information. As you can see, CCPA is not really concerned as much about that explicit opt-in. Again, think back to Counsel, think back to GDPR, as we just discussed. That explicit opt-in for being able to send emails or SMS on behalf of that company. CCPA is really concerned, again, about consumers' rights. What information is being kept, stored, accessed, shared, data breaches, right? Again, we're talking about that term again. It's about the data breach notification, not just to the authorities, but to the consumers. And then what the consumers have to do, right? So one of the interesting things about CCPA is that companies now have to have a feedback loop on their website or on their page that says, "Do not sell my personal information," that consumers can use to opt out of doing so. Similar, this should look the same sort of as GDPR, right? Consumers' rights to know about what information is being collected, used, shared, sold, disclosed, right to access, right to deletion. There's that right to be forgotten again, the right to opt out, and the rights to equal service. Again, this relates to those consumers or residences of California. So big. A big law that's really coming to its own. Again, that's really California based, but as you can quickly see, there are many other states that are following with copycat laws. And if I had a crystal ball looking into it, I would say definitely in the next probably 2-3 years, we're going to see some sort of a federal law as it relates to, again, the consumer protection, the rights of the consumer, making sure that information is not being shared or sold, accessed. It's set up and protected in a way, not just from like encryption or multi-factor, but there are firewalls and security around this information. So I often get the question, where to begin, right? What should I do? Well, you just threw at me all these different acronyms and laws and regulations that are happening. What do I need to do? I always say, number one, create your internal team of champions. You include people from marketing, sales, legal, IT, and security. This needs to be a team that meets on a regular basis to define roles and responsibilities, right? So, what is each team member responsible for? What tasks are they going to do? What information is going to be distributed to the company, and so forth, right? So, creating a data and system inventory of what information is being collected, right? So if I have a web form that comes in through WordPress and then synchronizes to Salesforce and may go to an email service provider, information flows and data mappings are important to see where this information goes. And again, who has access to it? Can it be exported? Do you have the ability to delete that information? And then look at gaps, right? So if your privacy program has gaps, identify those and make a roadmap. Prioritize those gaps and figure out task assignment and resourcing so that way you can assign those tasks and get those things done. CCPA is just the beginning. GDPR is just the beginning. 2019, 2020, 2021, we're going to see a huge wave of, in my opinion, improvements as it relates to consumers' rights and protection, but also things that are going to be, sort of uniformity for all companies around the world. Again, continue to monitor changes of the landscape and adjust accordingly. So, again, this is really where to start. Get that team of champions going and start to define those roles. As I mentioned, look at data collection and mapping, right? So standardize that process, who has access, how the information flows, where it goes, who handles it, and how it's disposed, right? So you think you're deleting the information, but actually what's happening is the database is replicated and being backed up in a different location. Oh, and that, by the way, there are 3 people that have access to that shouldn't have it, and their passwords expired 2 years ago. So understanding compliance around storing data is very important. And as Benjamin Franklin always said, by failing to prepare, you're preparing to fail. So start somewhere. Look at this now. Don't wait. This is, just going to get even more important, and you don't want to be the next Capital One, out there and be on the news tomorrow. So.
Very good. Thank you, Chris. One of the first places where people are preparing, especially on the global brand side, is in the contracts they create. And as we were talking about and preparing for this webinar, Howie on our team and I got into what I found wonky and very fun conversation about how often as an attorney in this world of marketing and event marketing, he's on the front line of businesses and brands trying to figure this all out. So his little section here, as you can see, Contracts in Context, is going to take us through what he's on the front lines of right now.
Thanks, Brent. So I'm Howie Cockrill, and I'm the Senior Corporate Counsel, heading up the legal department here at Opus. So I review and negotiate contracts of all shapes and sizes for the company, and I oversee all the issues related to data privacy here. Chris gave an awesome overview of 4 of the major laws dominating this landscape, that, CAN spam in the US, Counsel in Canada, GDPR in the European Union, and the CCPA in California, as well as some great ways to create systems and infrastructure for compliance, and what also can happen in terms of breaches and fines if you don't. In practice, these laws and the others that will follow them are half of the picture. The other half of the picture are the contracts, the data privacy, the data protection agreements between the parties who are handling all this data. So what I'm going to talk about today is just a brief history of how these contracts have evolved over the last year since GDPR went into effect. A couple of competing interests that legal departments are balancing when negotiating those contracts, and then some tips for how to improve that process for everyone. So how did we get here? So I'm going to talk a little bit about the evolution of data protection agreements. So DPA stands for Data Protection Agreement, and DPAs are to data privacy and information security as MSAs, or master service agreements, are to services on the business side. So MSAs and DPAs, you can kind of think of them in both of sort of umbrella agreements. DPAs lay out the legal and technical obligations of the parties around handling and protecting each other's data. So early in 2018, early last year, DPAs that were coming across my desk were pretty narrow. When the contract defined data protection law, it was basically referring to GDPR. When it was talking about what data was covered, it was talking about personal data as defined in GDPR. The required protections that were put on Opus, generic one-page technical and organizational measures. So basically, they were just taking language directly out of GDPR and turning it into a contract, which meant that there was less to negotiate, and the process was led by attorneys of all kinds, many with privacy experience and many without. So as the year went on, and companies on all sides of this started to wrap their arms around it a little bit more, the DPAs became much broader. Data protection law, as defined in the agreement, sort of became any applicable local, state, regional, federal law, or regulatory guidance or industry standard anywhere in the world that relates to data privacy or data protection or information security. So that was much broader. The data covered also much broader. In addition to personal data, it was just any information relating to our client's business, including but not limited to personal data, confidential information, and then of course any information derived from that data. So again, much broader. The required protections, so we went from a one-page generic technical and organizational measures list to a much more lengthy security requirements list, information security requirements list, and those can go on for 5 to 7 pages. So there's a lot more to negotiate with DPAs these days. And by and large, I've seen it change to being led by information security teams and privacy attorneys who know a lot about this stuff. So now that there's more to negotiate on the one hand, on the other side, the DPAs are now more flexible, which will allow them to adapt as documents to the legal and the technological changes that are coming. So what this means then is that DPAs are going to hold agencies to a very high and broad standard for protecting the client's data. And then the agency is going to need to turn around and flow that down to their vendors who are also handling the data of the clients. Meanwhile, the client and the agency event professionals are still catching up on what all this means, because they're out there on the front lines working with each other and with other vendors to meet the event deadlines. So this leads me to a discussion of the context in which all of this is happening. So I want to talk a minute just sort of about the psychology of the parties. So on the client side, their legal department and their information security team are in the mindset of be compliant. They aren't driven, client legal and client InfoSec are not driven by event urgency in the same way that the agencies are, because their legal and security, the legal and security aspects of their events is just one small part of what they do. So their turn time on contracts is often longer. On the other end of the spectrum, you have event professionals and event managers and marketers, and their mindset is go fast, because they are under enormous pressure to get the event done quickly and successfully. And historically, they've had a lot of latitude for how to do that. Now, with all these new laws and regulations, there's red tape, there's approval processes, there's new acronyms and tools they're not allowed to use. So this is a full paradigm shift for them. And then in the middle is the agency legal. So we're in the middle, balancing sort of in the middle of this seesaw between be compliant and go fast, trying to accomplish both at the same time while serving a real wide array of stakeholders, both internally and externally. As an attorney, I know that my client is Opus, but I also know that we're nothing without the clients who are hiring us. And we all have to work together to pull off these amazing events. So I have to understand our business, I have to understand our client's business, I have to understand the events industry and the specific event we're putting on and the applicable laws to get my job done. So on the be compliant side, this is ultimately the mandate of my job, and it's the language that's spoken by client legal and client information security teams. And then on the other side, go fast. There's deadlines that are always looming because the show has to go on. And this is the language spoken by event professionals and marketers. So I need to be fluent in both of those. And this sort of leads me to what I call the game of telephone. I'm sure that most of you are familiar with this idea of, the game of telephone where one person says something to the person next to them in their ear, and then they pass that on, and it goes down a line of people. And eventually, by the time you get to the end, the message may have changed. There may be inaccuracies in what's being said from what was said in the very beginning. And this is similar to what happens with the negotiation of DPAs, data protection agreements. So unless we, as the agency, just agree to the client's DPA wholesale, the process of understanding and questioning and negotiating these DPAs can be kind of cumbersome. As an attorney, we can't negotiate or discuss legal issues with non-attorneys on the other side who have their own legal representation, unless their attorneys consent. So that's what creates this game of telephone. The client information security team will talk to the client's legal, who then passes information down to client procurement, who then goes to the client event professional, who then is now talking to the agency's event manager, who then talks to agency legal, and then agency legal will then confer with agency information security. Meanwhile, the registration website for the event has to get built and QA'd and launched in 3 weeks, as an example. So, the role of agency legal is to sort of explain the go fast aspect and event realities to client legal, and the be compliant aspects to the event professionals and managers and marketers, and being compassionate and patient with both sides, but also being efficient and persuasive, all in the context of this game of telephone. So this is going to sort of lead me to the next thing I'd like to talk about, which is just some tips to go fast and also be compliant. So I think the thing that I would want to say to everyone, whether you're on client legal or on the the event manager marketer side, is that we're all on the same team. Just a reminder, new laws, contract requirements, processes, fears of data breaches, they've pushed people deeper into their own silos. But the clients, the agencies, the vendors and suppliers, we all need each other to pull this event off in a way that's going to be successful for the client and also respectful of the attendees and the trust that they've put in all of us as the stewards of their data. So we need to invest time in understanding each other's perspectives and experiences, because the more we can think like each other, the faster we can find compliant solutions that work on the ground at the events. To legal and information security team members, I would say be creative. Let's take a cue from our comrades in event management and be creative problem solvers, because we can be flexible and proactive without sacrificing compliance. An example there would be, the documents, there's going to be documents that store personal data. We need to agree up front on where those are going to be stored. And if we need to say, we're going to use this particular cloud storage, if the client doesn't want that, then they need to provide an alternative. We need to work together to anticipate these problems. Same thing with mobile devices. Event managers will need to use mobile devices on site. So let's get ahead of the game by setting up parameters that make sense. Same thing goes with last minute vendors, that web connected photo booth that collects names and email addresses is going to be on site in 48 hours. So let's get ahead of it. Let's agree up front on how approval and review of those kinds of things is going to happen. And then the last, I would say, to event professionals and managers and marketers, be informed, because you have to train yourself to spot these issues and keep learning about data privacy. You don't need to be an expert. There are probably people in your organization that are the experts, but you cannot bury your head in the sand or pass the buck any longer, because this is not going away. Please don't be a broken link in that game of telephone. Please do bring up issues as early as you can, so that the legal and information security team members can help you with it. You do have a really vital role to play, and we all need your help. You understand the event better than anyone. So, the clients are the data controllers. They're the ones ultimately responsible for the attendee personal data, which means that the agencies and the vendors are going to be looking to them for guidance and instructions. And we need you to be part of that conversation. And with that, I'll hand it back over to Brent.
Thank you, Howie. So last section is up here, and we're going to be talking about things that are moving fast, the world of emerging technologies. Before we do that, though, next up after this is the discussion. We have a few questions that have come in that'll be fun to dive into. If you've got your fingers next to the keyboard, now's when you should help get in some of those questions, because we'll be ready for them in just a minute. So back to the parts that moving fast, the world of emerging technologies. When we see this space, today and looking forward, there are really two buckets where the technology is changing the most. On one side, more tools for us as event managers and event marketers to capture data. And then the other is us as individuals. There's a number of technologies coming out that are going to help us get more protection over our own data. So we're going to start rapid fire here, and we're going to look at the capturing more data side. If you've been to an event in the last couple of years or been following along, you've probably seen this. Miguel's photo there, what is that? That is a kiosk that has facial recognition at registration. He walked up to the booth to register, it recognized him, and your badge is printed. Facial recognition is going beyond registration desks and into the world of marketing. What you see here is from South Korea. In South Korea, they have installed 10,000 digital displays that do facial recognition and motion tracking, where as you walk down the street, Minority Report like, it sees you, recognizes you, and customizes the ad. 10,000 of these across South Korea. On the other side, we can also start to go beyond just recognizing you and do some facial analysis on your, say, emotions. This is helpful for things like your keynote, putting cameras on the audience, and in real time, figuring out what the emotion is and how you can balance your message, to your booth or your activation, really getting a good sense of how you are connecting, again, at that emotional level with your audiences. On the other side, we've all been, we want to do mass data tracking, and we've all used things like RFID and Bluetooth. A set of new companies are coming out with new sets of technology to enable better tracking. What you see here, that little hockey puck-like thing on the left, that's from a company called Density. Density uses depth sensing technologies, and you can then, by putting these above doorways as an example, get you better and better data on the types of people, the number of people coming in and out of rooms. And if you want to be really creeped out, about a month ago in MIT Technology Review, they published a report on some new technology coming out of our very own Department of Defense. What does it do? Well, they figured out that everybody's heartbeat, much like our fingerprint, has a unique signature. And from a football field's length away, they can determine who you are as an individual. So now we're going to start having tracking technologies from a distance of pretty far, where we could follow and track individual people based on their cardiac signature. Now, this is coming soon. It's being in the labs. We still, as marketers, have a few years till we can start to use it, but think about the potential of where technology is going. And then get freaked out, which brings us to the second part, which is protecting our personal data. Really two things here that are of interest to watch. They're both emerging, but they're both getting some good traction in the early adopter technology space. On screen now is from a company called DID, and they are a repository, a database where you can upload your own face, and they will then partner with facial recognition firms to block you from facial recognition, a facial recognition firewall, if you will, if you're looking for that level of privacy. Again, emerging. And on the other side is something called solid pods. The gentleman who invented the World Wide Web, Sir Tim Berners-Lee, he is recognizing the problem of what we have out there in this day of Google and Facebook, et cetera, where we don't own our own data. Solid Pods is his idea, and it's out there now, where you can sign up, you set your own data in a pod, and when somebody needs access to it, you grant access to it. When you're done with that service, you cut off access and the service is not allowed to use it. Again, gentleman who invented the World Wide Web has a view for helping us protect our own data called Solid Pods. Where will these go? Big question, needs to be figured out on both fronts. But the point is, both fronts are showing a ton of movements around more tools to capture the data and more tools to protect ourselves. And that brings us around. So we are now at the end. We're going to go into the discussion. This is the world that we're playing in, from marketers to executives to attendees. We want to have that discussion around the topics today: privacy, security, and anything about that emerging technology, if anybody's not freaked out completely yet. So welcoming back now, Chris and Howie. The first question up, Chris, is for you, and it's as simple as, related to your title, what does a chief privacy officer actually do?
I guess it's a title that many times gets bundled in with a bottleneck, because I'm sure Howie can attest to this as well, that legal, privacy, and compliance oftentimes will hold up contracts or progress possibly on a project. Many times because, again, we're looking out for policies, procedures, and data governance. That's really what my job is as a whole, is to look at the organization and make sure that the team, the employees are trained and aware of anything privacy related, data security related. I also lead and manage incident responses, data breach notifications, preparedness, communicating goals, designing any sort of additional compliance documentation, mitigating risk as much as possible, and working with many different stakeholders, right? Everybody from the CEO, CFO, legal counsel. And one big thing that we're doing, as well as we're going through, internal auditing. We're going through many different iterations to prepare ourselves, not just for GDPR, Counsel, CCPA, and what's coming, but to also make sure that we're complying with the needs of our customers. Oftentimes, customers will come to us. We work with clients, large enterprises, global footprint, and they'll have needs or requests specifically related to a digital asset, an email, an event coming up, and we need to be prepared to help explain it, help them understand it in a way that they can relay it back to their stakeholders, but to also make sure that we're both covered from a compliance perspective. So whether that be sharing data, storing data, accessing data, encrypting data, it's important for the chief privacy officer to understand really what's going on from a contractual SOW relationship, but to also help make sure that the company as a whole is compliant with what they say they're doing and really having that governance.
Sticking with you, a similar question is, so if that's what's happening today and you dropped a whole lot of acronyms on us, what do we need to know next? Is there a new acronym coming out is the question?
Well, I'm sure there will be many different acronyms. As you saw, right, a lot of different copycat laws as it relates to CCPA. Texas having their own, Washington, Oregon, lots of the different states, right? And it's really the focus is on the consumer. We're also seeing a lot of things around the world, specifically in Brazil with their general data protection law. We're seeing a lot of things happening in Hong Kong and Uruguay and Peru and Chile. The world is coming to grips with a GDPR-like instrument as it relates to data protection and rights to the individual, and making sure that companies around the world are compliant, as well as secure. Nobody wants their data to be out there, whether it be on the dark web, whether it be accessed from a single engineer at Amazon in the case of Capital One. It's all about least restrictive privilege. And I think that, one bit of homework that everybody on this call can kind of take back with them is go back and look at the systems that you have in place, whether it be an email service provider, marketing automation, event planning portal, something that it relates to access, and go look at, do you have in your documentation, and is it actually being done, that you're removing people when they're terminated? I can't tell you how many times I worked with a client on a privacy impact assessment or some sort of an internal audit, and we review the logins, and you get well, that person's been gone for 2 years, that person's been gone for 3 years, right? Why do they still have a login? Why is that access still there? I could talk about password complexity all day long, and the need for that, additional security requirements, but the biggest thing and takeaway for what's happening, not just in the US, but around the world, is protecting the data that they have, controlling it in a way that is compliant with not just the regulations, but what the consumers is asking of them. Least restricted privilege, and sending it across to the processor whenever it needs to, but making sure it's done securely and with the utmost respect.
A question that'll take us in a little bit different direction, and this one is good for Howie. And thank you for that, Chris. And this one's good for Howie, is global laws. Chris just mentioned some of the state-specific laws again. You talked about DPAs becoming broader. A question is, what's an example that you faced where your requirements, say the InfoSec requirements, are divorced from the realities of what we're trying to get done?
Yeah, thanks, Brent. So we've seen, dozens and dozens of DPAs and information security requirements at this point. And primarily those are geared, they're sort of, one size fits all agreements that are going to go out from a client to any kind of vendor they may have or supplier under the sun. And they may work for the majority of them. Some of the things we see are specifically difficult for the event marketing, management, production industry. One of those I think I've seen is a requirement that if we're going to have a vendor, if the agency is going to have a vendor who's going to touch or handle personal data or client data of any kind, then the client wants 120 days advance notice of that, so that they have that 4 months to review and either approve or deny that vendor. That's just not tenable from an event perspective when you've got sometimes a client requesting a change in scope a week out, which is going to require bringing on a new vendor. It's our responsibility to make sure that we're flowing down our obligations to the vendors, and that we get DPAs in place with our vendors. And then of course the client does need to be able to look at and approve vendors, but 4 months is just we did have to negotiate that one.
Yeah, could imagine. We got, for those of you listening, we have about 4 questions left in the queue and about 10 minutes or so on our clock here to go. So if you have a question, it's been sitting on your fingertips, type it in, and we will still have time to be able to get to it, or should have time to get to it. So we'd love to get those in. So one of them that came through is actually near and dear to my heart, because I make this joke a lot, which is, the question is a big part of the solution that we have to do on the data privacy side just as simple, or my interpretation of this question is it just as simple as updating the terms and conditions on our forms for registration, data capture at an event? I like to joke, is it as simple as just putting that little bar across the bottom of the site that says accept cookies? Like, how, if it's not as simple as just updating your language, what are some of the other big picture solutions that are coming out that we need to make sure we're doing?
I'll start with that. I'm sure Chris will have some things to add.
Yeah.
So the way that I think about it internally is I kind of have 2 parts of my brain when there's an event coming up. One is the paperwork we have to have in place with the client. So that's the data protection agreement. And then often we will attach to a statement of work what we call a data protection exhibit that is listing out all the people, all the vendors we're using, like all the data we're handling and all the vendors we're hiring and all the data that they're handling. So that's the client side paperwork. And then of course there is what this person is talking about, which is what's actually on the attendee, on the registration website. And our philosophy there is we are a data processor, which means we are following the instructions of the client, who is the data controller. We That said, this is not our first rodeo. We've done this lots, and in fact, we've seen how lots of clients do it, and we have sort of an idea of what sort of industry best practices are. So we may suggest, you know, we can say, here's some language that you could use, but, you know, please have your counsel review this. And it's going to be depending on where the event is, you know, whether you can have an opt-in or an opt-out. You know, if it's in a territory that is going to have attendees from Europe or is being held in Europe, then of course it's going to need to be opt-in. And then there may be specific things that are related to the event, but that aren't required for the attendee. So for instance, if you want their permission to do things with their information for the event, that's one thing. But if you also separately want to be able to market for that to them after the event, that would be like another opt-in. You may also have specific terms and conditions for the event. So that may be another thing you want to link to. And then, you know, you get into other things around, you know, disclosing, you know, accessibility issues or food preferences and allergies. These are all things that we go down a checklist when we are putting out an event registration website.
Chris, do you have anything to add to that one?
Yeah, I always, so just working with clients on that, you know, terms and conditions or, you know, privacy policy page, I often like to print it out and put it in front of the client and say, can you tell me that you do all of these things? And oftentimes it'll say like generated by privacypolicygenerator.com. It's like, wait, so you just copied and pasted this from the internet and you are not doing any of these things. Things like, we are going to make sure that your information is stored in a tier 1 data center with physical security access and, you know, 1024-bit encryption and all of that. And it's like, okay, well, show me that you're doing all of these things, right? So it's not as easy as just putting up terms and conditions. It's also about abiding by those and making sure that you're respecting the data that you're being given and collected. And again, stored and accessed in a way that the consumer knows about. And I think that's really part of the issue too, that, you know, as Howie mentioned, there's the legal side, but on my side, it's the, are you compliant with what you're telling the consumer or telling the, you know, the individual when they're signing up or they're opting in? And oftentimes the answer is no. And you have to go back and review those, you know, terms or review those conditions and make changes so that that way you can say, yes, now we are abiding by those T's and C's.
And I would actually just want to add real quick that I think just generally speaking, the legal teams and the information security teams there's a need for us to work together closer than ever before and to understand each other's, you know, language and psychology in a way that we never have before. And I think it's an exciting time, but it's also a time, you know, it's going to be a transition for a lot of legal teams and a lot of information security teams.
So here's a question that plays a little bit into that, and for either of you to jump in on, which is, and it will require a lot more working together if I'm internalizing this question correct, which is, it feels like we are in a state where brands can either look to follow the highest common denominator, like we follow all the rules and our checklist is the same no matter what country we're in, or quote unquote here, find the opportunity. If you're doing, in our world, if you're doing an event in Asia or Europe or United States and you tweet and you don't have to follow all those rules locally, and maybe you can get better data to, again, for the right reasons, to add value to your business and to the attendee, et cetera, should you be going after that? So again, philosophical question, but should brands be going highest common denominator, or are we at a point where we could start to find, if I'm internalizing this right, should we try to find the opportunities where they may lay?
Yeah, and I'll start with that one. So I think the biggest thing is brands should really try to comply with the most restrictive laws, regulations that are out there, GDPR per se, really for the fact of if you have everything buttoned up and if you are doing things like not just the explicit opt-in part, but the data mapping, the field mapping, data storing, collection, consent, access, right to be forgotten, all the nuances as it relates to, you know, doing business in 2019. That's going to give you a competitive advantage on, salespeople can sell anywhere. You know, you'll be able to work projects pretty much anywhere too as well. And it'll also give you the leg up as it relates to, well, I'm going to take a shortcut and just be compliant here, but oh wait, now we have an opportunity over here, but we can't go after that opportunity because the RFP states that we need to be GDPR compliant, right? And so there's a lot of thoughts around this, but my thought is that if we go with the most restrictive policy and regulation, we're going to be multiple legs up on selling, on complying with RFPs, and being able to kind of fight and combat against competitors as it relates to winning that SOW and client.
Yeah, and I would add a couple of things. I totally agree 100%, of course, as as the attorney on the line with everything Chris just said. I would also add that, internally, there's a lot of work to get people to understand, who aren't in legal or information security, to understand what they're required to do. And, when you start trying to get into the nuances of, well, because this event is happening in Singapore where you can actually do X, Y, and Z, then I think the overall message gets lost a little bit and diluted. So that's one perspective. That said, I have worked with clients who, because they've got 7-8 months to prepare for an event, the event's not right around the corner. They do have time to really tweak out that, that reg page, that registration page, and identify, where attendees are coming from, and then target the different versions of the event page to different people depending on where they're coming from to comply with their laws. So that's something you can do if you have time. But that said, with events, sometimes you don't know where all your attendees are going to be coming from, and then you're sort of back to that highest common denominator, which I think is by far the easiest and probably the best solution for most events.
So we got 2 questions in a couple minutes here. Anybody listening, if you have any of your last questions, last call for questions, go to Chris with this one first. How do you stay on top of all this? What are there blogs you read, newsletters? How do you, in your role, or how can our listener in this case, follow along like you do?
The IAPP, the International Association of Privacy Professionals, is a great site and resource. I'm a member of it, been a member for many, many years, and have multiple certifications through them. They provide a great daily newsletter, blogs, webinars, white papers, training courses. A great resource overall, not just for the United States, but for things like GDPR, Counsel, things that are happening over in Asia. It's a great resource. InfraGard is another one. InfraGard is it's a nonprofit. It's a partnership between businesses, individuals, and the FBI. The Atlanta chapter is really active, and I do a lot of things with InfraGard on, not just speaking, but also sharing information, sharing knowledge, specifically as it relates to compliance, legislation, and security. And I would say the last one that I've been a part of for many, many years too, as well as a group called MAWG, M-A-A-W-G. It's the Messaging Malware Mobile Anti-Abuse Working Group. I know it's a mouthful. It's another acronym. But we do a lot of work around, not just email or events, but things like malware, viruses, mobile security, internet security. It's great site, great resource, and they have a lot of good resources to point to as well.
Thanks, Chris. And then Howie, you get to take the last one home, and it's off the acronym. How does an attorney, inquiring minds want to know, how does an attorney stay on top of the world of technology today?
Yeah, that's so I would 100% agree with Chris on the IAPP. I've found them to be a real invaluable resource, because of all the documents and templates they have on their website, but all the blog postings and then the emails they send out and the events they have. It's just that's probably my one-stop shop. I also am fortunate that my company decided to invest more deeply in the legal compliance for data privacy and security. So we hired another attorney who's focused 100% on data privacy. So he's out there on the front lines as well, going to webinars like this and scouring the IAPP and other resources like Chris mentioned, and then coming back to me with summaries, which is amazing, an amazing resource to have.
That's awesome. So we're going to take that into the wrap up here. One last slide, which is not really a joke, but it could be if the three of us ever get together at a bar, a chief privacy officer, an attorney, and a marketer walk in a bar. What are we going to talk about? Well, what we're going to talk about is really probably this, which is all this work we're doing around getting data, protecting data, the effort, that game of telephone, the staying on top of the acronyms. As an industry and as the three of us on this phone, we're locked in on these two big questions. We're going to put all this effort in. Let's make sure that our attendees are getting value from the data they're giving us. Let's not just track their heart signatures because we can. Let's make sure they're getting value. And on the flip side, for our businesses, from the business overall and your ROI driving at a high level to your sales teams, your marketing teams, if we're collecting this data, let's make sure it's being used. Drive the funnel, drive next year's event, etc. That's our mantra, and that's what we got to roll out on here. So last slide. Thank you, everybody, for joining Chris, Howie, and myself. You can get the slides. You can join the newsletters. You can connect with any of us at opusagency.com/data webinar. As we wrap this, you will get a survey just about this program. We'd love to hear your feedback. We got more webinars like this and on many different topics, as nerdy as this and more fun as well, depending on what you find fun. So we'd love to hear your thoughts on this so that we can keep improving with you and for you. Thank you, Chris. Thank you, Howie.
Thanks, Brent.
Thank you.
And that's a wrap. Oh, thank you. And that's a wrap. Thanks, guys.